Okay, so as you guys may have seen if you looked at Facebook at all in the past week, the Supreme Court is dealing with gay marriage. And there are two big cases that were argued today and yesterday. The first one is the Prop 8 case, and the second one is a case called U.S. v. Windsor, which is about the Federal Defense of Marriage Act. Now, the Prop 8 case, as you know, is when California passed a constitutional amendment saying that gay marriages in California were banned. DOMA is a federal law which prevents states from recognizing gay marriages performed in other states, and also means that the federal government does not recognize gay marriages performed at the state level. So basically this challenge is about whether those laws are constitutional. The first one, Prop 8, is relatively straightforward. It's saying that banning gay people from getting married violates the Constitution because it violates equal protection and discriminates in an impermissible way. That's the argument that the gay marriage, nice people side is making, is that under the 14th Amendment, due process, equal protection, you can't discriminate against gay people from getting married. The idea is that it's either irrational discrimination or a slightly higher standard that says gay people are a protected class analogous to race or gender, and that institutes special protections that mean it's more difficult to discriminate against gay people. The argument in DOMA is slightly different and is actually twofold. The first is basically the same equal protection argument that the federal government can't discriminate against gay people from getting married or from recognizing gay marriages. But the second is that DOMA is a violation of states' rights, saying that the federal government cannot force a definition on marriage to the states and is thus unconstitutional that way. Now, obviously, apparently all Supreme Court cases, it's very likely that these cases will come down to 4 liberal justices, 4 conservative justices, and then 1 swing vote in the middle. For DOMA, it seems very likely that that is going to be overturned. SCOTUS law gave it an 80% chance of being overturned. The New York Times said at least 5 justices, possibly 6, were extremely skeptical of the law. But the problem is, it's very likely that if DOMA is overturned, it'll be overturned on state rights ground, not equal protections grounds, which, even if it's overturned for that reason, is good, but it's not quite as much as we would have hoped for. If DOMA is overturned on state rights grounds, which seems to be the way Kennedy would overturn it if he does choose to overturn it, it means that states have to recognize gay marriages performed in other states, and the federal government will recognize gay marriages. So as long as you have the financial resources to travel to a state without a residency requirement, you can get married there, and your marriage would count even in states that don't allow gay marriages to be performed in those states. But that still means that gay marriages can't be performed in a lot of states, and if you don't have the financial resources necessary to travel to a state like New York from, say, Georgia, you're sort of out of luck. Prop 8 is a bit different, but the consensus there also seems to be that it's unlikely to be upheld. But the problem there is the Supreme Court can deal with Prop 8 without addressing a lot of the underlying equal protection issues. It's possible that the Supreme Court could say it only applies to California for a variety of reasons, or another narrow holding saying it only applies to, say, the 9 states that have civil unions but not gay marriage, saying that just denying the name marriage is irrationally discriminatory and vindictive and thus is impermissible. Or you could base it on a case called Romer v. Evans, which Kennedy also decided, which is where if you have already granted gay people certain rights, prohibiting them from accessing those rights in the future is also irrationally discriminatory and vindictive. Or it's possible the Supreme Court could just say, fuck it. The people appealing Prop 8 don't actually have standing to appeal, and that the entire judicial process from the Ninth Circuit on up to the Supreme Court has meant little and nothing. That means California still gets gay marriage, but it doesn't apply to any other state, even in principle. And it means that you would have to find another case about gay marriage and go through the trial phase, the appeals process, all the way to the Supreme Court, which could take anywhere from 2 to 5 years before you could get another case addressing gay marriage. So in summary, it's very likely that these cases are going to result in wins for gay rights. There's a very good chance that gay people will have at least federal recognition of marriage, and also a very good chance that they will be able to get their marriage from other states recognized in any state. And there's a very good chance that California and possibly a few other states will get gay marriage, will get equal marriage. Yes, California and Oregon are actually going to get marriage. But it's very likely that California and possibly a few other states are going to get marriage equality. But there is no guarantee that the Supreme Court is going to address a lot of the underlying marriage equality issues, and it may be a few years before we get to the point where the Supreme Court has to address those things.